So delighted to co-host this discussion of the LKQ versus GM case, particularly where it's headed after the oral argument, the first en banc oral argument in a patent case that the Federal Circuit has held in a very long time. I'm really delighted that my co-host Chris Carani is here, since he knows a whole lot more about design law than I do, and works with designers all the time. So when we get to the really hard questions, I'll push at him and he can push back at me on those. I'm going to turn it over to Chris to run it. Before we go ahead, I need to thank our co-sponsor, IPLAC. These are always wonderful events to co-host with such a great organization with such great lawyers. So with that, Chris, take it away.
Thank you, Professor Sarnoff. It's very nice to be here again. Chris Carani from McAndrews helped Malloy here in Chicago. And it's a thrill to be here. Thanks for everybody coming. It's nice to see some familiar faces, some new faces, people interested in design law in general. And we're going to talk about this, the case LKQ versus General Motors. And there is certainly a Chicago connection to this, is that LKQ, I didn't know until I started really studying this case, that LKQ's headquarters are actually in Chicago, and furthermore in our offices, which are 500 West Madison, in the building there, the Ogilvy Transportation Center. So there's certainly a Chicago connection, and let alone the connection with respect to the American auto market, having General Motors being the other side of the V in the particular case. We'll walk through. Go ahead, Professor.
Before you go ahead, we should also probably say that we both filed amicus briefs in the case. We both attended the oral argument. I helped LKQ with mooting their oral argument, but the views that we're going to express are solely our own, and even we don't believe them. So there you go. Right.
Yeah, no, this is true. There truly was, whenever you get an en banc case, and for en banc, for those who are maybe perhaps not familiar, the en banc case is comprised of all of the active judges on the court. So that would be all 12. Well, typically you'll have a panel decision, which is comprised of 3 judges. Here, and when it decides to go en banc, you'll have all of the active judges. As far as, there's one little loophole in there, is that if on the panel decision that would have preceded the decision to go en banc, there was a senior judge who was on that 3-judge panel. The senior judge can elect to participate in the en banc hearing and the later phases. And in this particular case, there was that. We'll get into the sort of scorecard in a moment of the various makeup of the en banc court. So LKQ versus GM Global Technologies. Josh and I were both there. In fact, we wait because it was a very long line to enter the courtroom. If you haven't been out there, the Federal Circuit, it's just right next door off of Lafayette Park, next to the White House. And when we got in, it was effectively standing room only. The place was totally full. The last time I had been there was actually for an en banc hearing, was in 2008. And that was the last time the Federal Circuit has had an en banc hearing in a design patent case, and that's the seminal case of Egyptian Goddess v. Swissa, which really was changed the law in design patent infringement, getting rid of what they used to call the point of novelty test, and also significantly not an absolute rule, and we'll get into this a bit, but up until that point, up until 2008, and after Markman in 1995, many district courts were treating design patents like utility patents in the phase of claim construction, and the idea of construing the claim. Their mandate is to construe the claim to try to remove any ambiguities in the claim. And so what was happening after 1995 up until 2008 is the courts were writing verbalizations of what, if you had a ceiling fan, they would try to describe it in words, thinking they were discharging their markman duty. Imagine if the projector that's up on the ceiling, if you had to sit down and describe the aesthetic appearance of that in words. It is sort of a fool's errand because the words are just not really equipped for describing many types of shapes like that. And after all, at the end of the day, the test for design patent infringement, we'll talk about Gorham v. White in a moment, is a visual test. It's an ocular inspection of the claim design and the accused design. So what the court ultimately in 2008 had done in that case, in the Egyptian goddess case, and it might come back into play here, so we'll take note, is that they didn't lay down an absolute rule. They didn't say you, the district court, cannot construe or verbalize a design patent claim. But they did say this. They said, as a general rule, you should not go down the path of trying to verbalize design patent claims. Let the pictures speak for themselves. And I think in this in this world where the Federal Circuit is certainly concerned about being reversed by the Supreme Court, that was a way to sort of insulate them from laying down what could be perceived as a rigid rule. Don't say that word. The rigid rule that the Supreme Court doesn't like. And so having that sort of softer, maybe a declaration as a general rule with exceptions is something that will come back into play in this particular case. Tons of amicus support, as you would expect. Big ticket case, and you can see down there, there was the patent law, and if you have a chance, I commend you to read Professor Sarnoff's brief in the case. Brought in a lot of ideas that weren't in the other amicus briefs, which makes for a good amicus brief. It's not a Me Too brief at all. Then there was the support for General Motors, you can see was much more on the side of the automotive companies, the Industrial Designers Society of America. Apple had an important brief there. IPO, INTA had filed briefs in sort of GM. And then you have in support of neither party, the Solicitor General, who was actually participated in the oral argument. You have AIPLA, I highlighted that one there because that was the brief that I had authored with my partner, Dr. Dunstan Barnes, also a partner at McAndrews. And New York IP law, and then this very interesting brief by the Institute for Design, Science, and Public Policy, which is a group of cognitive designers, but also those versed in sort of cognitive science and putting together, the assessment of science and viewing spatial relationships of items. Those were the main briefs. Okay, the designs in the case.
Keep going. You're doing great.
Okay. Designs. So what had happened in the case, you have these two different car parts were aftermarket parts. This is a big battle. In many countries, keep in mind, you can't get design protection. For instance, in Europe, the European Design Directive, there's an express exclusion for must-fit, must-match parts. Sort of where the right to repair doctrine has really affected legislation. It's included in the most recent version of the European Design Directive, which is going to be coming out later this year. But in the US, we have been able to get design protection on these types of items. A front fender here, a skid bar were both in play. Now, here comes there was some prior art references. There was a challenge in IPRs at the Patent and Trademark Office, where this is like a post-grant analysis for those not familiar with what an IPR, inter partes review. And so there was a couple of references that were set forth here and determining whether or not those references either A, anticipated, meaning that they destroyed the novelty of the claim design, or B, rendered it obvious in view of the prior art.
So let me just focus your attention for a second on these pictures. So this is the claim design, and again, a picture's worth, what, 50,000 words? I don't know. And you'll notice that this is a round shape in the wheel well. The primary reference looks pretty similar. You've got the same little notch, you've got a little thing here, you've got these things here, but this is not rounded in the wheel well. In contrast, the secondary reference is rounded, right? So now you know what it is that the designers were alleged to be putting together in the prior art to ask whether this design is obvious in light of what was already known.
Correct. And so you're seeing these two references. And for those who are, practice utility patents, when you come to an obviousness, this is very commonplace. You'll see sort of a primary reference, and then you're seeing a secondary reference in view of adding it to. In the design, it had been a requirement that you begin with a primary reference that is not only a starting point, but also having a requirement of it being basically the same. So there was sort of a qualitative requirement to establish a starting point. I'll also note as an aside that in most of the rest of the world, when it comes to design systems, you don't combine references at all. They're never, not like you do in a utility patent context where you're combining references. In most of the other systems, it's just a singular look at the claim design or look at the registered design and compare it to a single piece of prior art. So you don't have this notion, which has led to a lot of confusion here, is when is it appropriate to mix and match and to add and modify designs? And what you'll see in designs, particularly in crowded art areas, is that every single line, every single curve, every single surface is found somewhere in the prior art. That's just the nature of design. And the challenge here is, because everything is possible and everything is already in the prior art, when is it obvious to make those modifications? It's all, any designer can put an extra, can make that flat. Any designer can make that straight, can make that rounded. That's not, it's all within their skill set to do that. And it's all in the prior art. But the question is really focusing on when is something to be deemed obvious. Go ahead, Josh.
Sure. So again, this is just another view of the same figure from a different perspective. LKQ is a large aftermarket auto parts provider, the largest in the country. It imports a lot of post-production parts for use in repairs, and therefore competitively is able to reduce prices of repairs for anyone who's interested in concerns about repairs. There's a separate white paper that I've written a number of years ago on why, like Chris says, in many other countries, you can't get a patent on a design for a repair part that must match. In our country, we need at least an infringement exemption. But in any event, the challenge, LKQ had been licensing. For some reason, the license stopped, and they then decided to bring this action in the patent office to try to invalidate the two patents at issue. And the patent office concluded that they had not demonstrated by a preponderance of evidence that either of the patents were anticipated and would be obvious, on the primary reason that there was a legal doctrine that you've already heard, that this primary reference had to be basically the same, and they said it wasn't basically the same, right? So that gets appealed. The initial panel affirms the holding of the patent office that this was not basically the same. Judge Lurie writes separately to emphasize the importance of not having, my words, a loosey-goosey test of obviousness, but really requiring it to be kept very close to the prior art through the basically the same approach, and then have just simple modifications to that basically, the same reference. In contrast, Judge Stark seems to suggest in his separate concurrence that if that wasn't the test, he might come out and say it was obvious. But he's bound by the test because that's the past precedent of the Federal Circuit to have this Rosen reference and then a second legal standard, which is the Durling test, saying that the secondary reference, the reference from which you're taking the modification, has to be so related to the first reference that it would itself suggest making that modification. Okay, so it goes on banc. Judge Newman, for various reasons, has been disqualified from sitting. Judge Cunningham had, I think, a conflict, and Judge Clevenger, who was on senior status, but was on the original panel, chose not to sit. In contrast, Judge Laurie chose to sit. And then Judge Stark had joined the court, so Judge Stark also sat on the en banc court. And this is a picture of what it looked like sitting in the back with a panel of judges in front, loaded for bear. Mark Lemley, the counsel for LKQ, got 2 sentences out before Judge Moore cut him off and started asking a question going to the heart of the case. Let me turn it over.
Sure. So, and if you're listening to the audio, I did listen to it afterwards. Being there in person is really interesting because you can see some of maybe little side discussions or judges maybe whispering to the judge that's next to them and really associating the names with the face. And it's important because one of my sort of personal observations is that the tests that we're talking about, and you heard this, the Rosen-Durling test. We'll explain that in a moment. That's the existing test for analyzing design patent infringement. It comes from 2 case names. It's been around since the early 1980s. And so several of these judges that have been up on the bench for a long time have been operating using those tests for almost 3 decades now. And my sort of sense is that you have the older guard who is very comfortable with this test and maybe understand the importance of the test, and you have some of the newer, more junior judges who perhaps haven't even had that many design cases in their career. I mean, this is not that often. I mean, it's very often if I'm going to a district court and I'm going to be arguing a case on claim construction or infringement, it's usually the first time that judge is having a design patent infringement case. Whether it's educating on claim construction or educating on the test for infringement or some of the other aspects, how is it different? Their perspective is usually coming from utility patent law, and I'm a utility patent practitioner my entire career, but using that as your pivot point to sort of understand where is the similarities, where is the differences. This issue of should obviousness even apply to design patents has been out there for a long time. The 1952 Patent Act, there was a big question. Should we even apply? Should 103 obviously doesn't even apply to design? Doesn't even make any sense? Or should we do what a lot of other countries in the world look at as just novelty for design? But for whatever reason, we've chosen to also apply obviousness, and it's created some issues which Judge Rich finally, famously in 1981 says it's the impossible issue of obviousness for design patentability.
And I'll jump in. This is a result of a decision by Congress in 1842, that's a long time ago, to not put design into the copyright law where it belongs, but to put it into patent law. So from the beginning, we've had a problem trying to figure out how to patent law concepts apply to design. We'll come back to that when we hit the Gorham case.
So now we've got this evolution of from the court calling it an impossible issue, and then a year later they sort of come up with something, this In re Rosen test. It seemingly has been working for a while, but it had been percolating in the background with some of the other issues. And the court lays out 7 questions in its en banc order, saying we need to sort of clean house on this particular issue. And I tip my hat to Josh and to Professor Sarnoff and the others. I was involved in Egyptian Goddess at the petition for en banc. Once you get to the en banc orders granted, people flood in, okay? Because they know that's already been, it's a live issue. But believing in an issue at the petition for rehearing en banc, to me, that's a special moment because you have to really believe that issue to really invest the time and the energy into that brief. And because most of them, I mean, it's so rare that anybody of these would actually be granted. And I was really, I followed this area of the law very, very closely. And I could think about the top 20 issues that are in my mind of what need to be cleaned up in design law. This was near the end of the list. It wasn't up at the top. But nevertheless, they got the court's attention to take this particular issue in a real way. So they have definitely got the spotlight. And what was the hook was, does KSR, the Supreme Court's utility patent case from 2007, overrule or abrogate In re Rosen or Durling spectrum? Those are the sort of the prevailing design cases.
Yeah, so again, we didn't frame it that way at the petition stage. That came straight from the court's own language. And as many of you know, the Supreme Court doesn't feel bound by lower court precedent at all. There's simply no reason to overrule or abrogate. They should have just asked, is, Durling and Rosen, are they inconsistent with KSR? So we'll just proceed on that as if that was what they had asked.
Right. So the open doesn't overrule, but then the second one, you can see quickly, they say, okay, assuming it doesn't, because, they didn't mention the case, how would they? Should we have to modify? But this was the entree for them to decide, okay, should we modify the Rosen-Durling test? And this is one of the big questions is, okay, if you're going to disrupt the current test, which has been in place for, 40 plus years, the USPTO is using it, the PTAB is using it, judges, the public is using it. What are we going to put and replace it with? If you think it's a bad test, we don't want to replace it with another bad test. So this was a key part. I'm not sure it was ever answered. Here's what should the test be? Question 4, is there any precedent? Question 5, the obvious, would it cause any uncertainty if we were to eliminate this test?
And that's important, again, because there are a lot of patents that have issued under the Rosen and Durling standard, which, at least in theory, might not be valid under a more permissive means of showing obviousness. So, when people invest money, they'd rather not see the money get taken away. Similarly, if they get the patents, they'd rather not see them get it taken away. But these decisions, because they're judicial decisions, will apply retroactively.
Correct. And the last one they sort of hit, and this was something in Judge Lurie's opinion at the panel level, was that what differences, if any, between design patents and utility patents are relevant to the obviousness inquiry. This is a continuing theme. We call them, it's all underneath the Patent Act. So you have utility patents and design patents all in there. And oftentimes, most of the case law is being created in the utility patent context. But there's sort of this attempt to try to just piggyback it, but oftentimes it doesn't work. We don't use the all elements rule for determining infringement that you use in utility patents, right? You look at this, each one of the claim limitations is a precedent in the accused instrumentality. We don't do that. We use the overall appearance, the ordinary observer test.
So let me just clarify that, though. When we say we don't use the all elements rule, the question is design somehow different because we view design as a whole? And the answer, I think, actually, which I think Chris may disagree with me on, is it's actually not different because you have to have all elements to make the whole of the claimed invention or you don't infringe. So I think that there's a slight mischaracterization that goes on when they say, we don't use the all elements rule. We don't break down the visual design into elements, although sometimes we do. We actually say it's this curve, this whatever, and they're being put together. You have to see it as a whole, but invention is a whole too. So,
yeah, I mean, we don't use an all elements rule. If you have, well, why don't we just take the spoons out?
Yeah, take the spoons out. Let's get there. And let's move on.
Yeah, go ahead to the next slide. Well, if you have two things that are substantially the same, or two designs.
Yeah.
I happen to have with me, and I just love when I teach at the IP class over at Northwestern, I like to do the show and tell with these. These are, maybe we can see online, the actual spoons from Gorham v. White from 1871 from the Supreme Court case. And in that case, you have the claim design, which was Gorham's claim design, which is claimed with using drawings, and you can see it there on the left. And you have the accused White's design, which was also shown here on the right. And
these are hard to find, by the way.
I'll hand them around so you can see them in person. But the key is that you could see any particular curve, any particular rosette, any particular ornament. It's not required for there to be a finding of an infringement. It's not dispositive if you don't have that. What's dispositive, as the Supreme Court said, is the controlling impression upon the eye of the amalgam, of the composite. So to say that there's, oh, you're missing that line or missing that line, that's not going to be dispositive. The only question, the operative question, is whether the overall, the amalgam, the ensemble is there in its entirety. So I'll hand these around, but that's sort of how it differs in that respect from.
So let's go back.
Okay, so let's just,
Yeah.
we got a bunch to go. Okay,
So
so
we should probably be moving forward more quickly.
we will.
Yeah,
So,
okay.
the two key issues here, is there a primary reference? Is there a secondary reference? So what the court has set up is this idea that we want a starting point. We want a single reference that is something in existence, the design characteristics, which are basically the same. That's what they call the primary reference requirement, coming from the case In re Rosen. And they said you had to have a starting point. So could you just start from, a single atom and then start adding in other aspects? No, that's not what they wanted. They want you to have something that is a construct, something that is basically the same. That was the phrase that they had used. And then the second issue here is that presuming you do have that starting point, that basically the same reference, it's not at that point anticipatory, otherwise it would be the same design, and that would just use that for novelty. But if there are differences there, when and how can you modify that reference?
So there are 4 basic statutory requirements for any patent. It has to be novel and non-obvious. If it is a utility patent, it has to be useful. If it is a design patent, it has to be ornamental. And you have to provide a written description of the invention in the specification that's both sufficient to show possession of the invention at the time it's being claimed, and also that you've enabled people skilled in the art to make and use it. The one other thing is that Section 171, unlike the utility patent requirement, adds another provision when they created the design as a patent requirement, saying that unless Congress specifies otherwise, designs will be subject to the same requirements, these 3 requirements, as utility patents. Whether those requirements should be modified for design then becomes the operative question, and that goes back to the fundamental question, is design really different or is it not different? So we'll come back to that. Won't go into much of the history of the design. The Durling and Rosen tests really came out of Jennings and Clavis and some other cases back in the 50s. So this has really been around in the lower courts for a long time. But in the Supreme Court, to my knowledge, the only obviousness case they have is the Whitman-Saddle case. So, and that's back in the late 1800s. So we're talking about whether or not the Federal Circuit has been out of compliance with the new view of Supreme Court decisions about what obviousness means since at least 2007 and possibly all the way back to the 1800s. So as Chris said, if it's not identical, if it is identical, it is not novel. So you fail under the novelty test, but that rarely happens. So you look to obviousness, and obviousness is the language of Section 103, notwithstanding that the claim invention is not identically disclosed, set forth in the novelty provisions of the prior art. If the differences between the claim invention and the prior art are such that the claimed invention as a whole, again, as a whole applies to utility patents as well, would have been obvious before the effective filing date of the claimed invention, and this is a critical language, to a person having ordinary skill in the art to which the claimed invention pertains. Note they use the word invention, they don't use the word design, but at the same time, the most important thing is this is being viewed from the perspective of the skilled artisan who is asked to determine whether or not this would be obvious. It is not the perspective of the ordinary observer, unlike, as Chris has correctly said, the courts have held is the test for infringement is viewed from the eye of the ordinary observer. That might make you think maybe the court has had it wrong since the Gorham decision, and this should all have been viewed from the perspective of the skilled artisan, here a skilled designer, but we'll come back to that as well. Okay. In 66, the Supreme Court provided a test for how you go about the process of determining obviousness, but it based on that statutory language, but it did not actually tell you what obviousness means. If anybody can tell us what obviousness means, it would be really helpful. Some of us filed amicus briefs in the KSR asking the court to give us time, money, and effort thresholds. Of course, they refused to do that. But the basic idea is you have to decide what was previously known in the prior art to the public and to these skilled practitioners, what the differences are between the claimed invention or design in the prior art, what the level of ordinary skill in the art is, and then you can make a prima facie determination whether or not it would have been obvious to that person, either combined with objective evidence about the commercial context, which provide inferences about obviousness, or you can make the primary facie case first and then consider those to say they may rebut a prima facie case. Those commercial considerations are the invention's commercial success with some nexus to the nature of the inventions and its desirability, long felt but unresolved needs, failure of others, skepticism by experts, praise by others, teaching away by others, recognition of a problem, and copying of the invention by competitors. The important thing is those things give you inferences about why this wasn't made already. That's always the question. If it's obvious, why wasn't it made already?
Right, and I will note in those, remember the policy reason of why we even have obviousness. If it's not novel, we as a society already have that invention. We already have that design. What the policy reason to obviousness is saying, well, we would, if it's something that's within the skill set of one of ordinary skill in the art, maybe it hasn't been created yet, but we don't have to tease that out. That's there for the taking, because one could just easily make that who's ordinary skill in the art. We don't need to incentivize that any further in order to have, so we already have that, so we don't want to provide this monopoly right. So it's those things that are within the skill set of one of ordinary skill in the art. I'll note also on the Graham John Deere, you look at those three, for 1, 2, and 3, there's never been a debate that those apply to designs. But this doesn't really tell you, these are really broad platitudes as to what, about to analyzing this issue. This is not, and then you look at those factors there, none of those really have any meaningful application to design law. Long felt but unresolved needs, failure of others, these are utility patent ideas. Teaching away by others, that has no application to design law. Recognition of a problem, so it's really putting a square peg, and this is my personal opinion, into a round hole to even be using many of these types of things.
I'll just express that they could be relevant. Again, long felt but unresolved needs. The question is what do designers do when they're thinking about trying to make particular aesthetic appearances? There could be that somebody wanted a really sporty car and they hadn't gotten one of the right kind yet. And therefore there was a long felt but unresolved need for a really sporty looking fender or something. Again, this is the question about, does design really differ in terms of how designers go about it? And sadly, the court noted during the oral argument that there were only 1, maybe 2 briefs from designers, and pretty much everybody who was filing who had skin in the game was from the automobile-related industries. So we don't have a very good evidentiary base to figure out what the level of ordinary skill in the art is across all the different potential fields of design.
Yeah, I mean, because we're not just talking about aftermarket parts. I mean, what's being proposed here is an across-the-board revamping of the design obviousness law, which applies to anything from automobiles to sporting goods to consumer electronics to medical device, medical tech, all the way to virtual designs, to GUIs, to icons, to animations. This whole panoply of potential subject matter. And some of the judges noted that, said, boy, we got this one issue. We're hearing from such a we're hearing from the insurance companies and the aftermarkets, and we're hearing from some car companies. Where is the rest? Now, there was briefs there. I would commend your attention to the Industrial Designers Society of America. That's the largest industrial designers association in the United States. They filed a brief. So hopefully Judge Reyna found that brief. And there was also the brief that was filed by Charles Morrow's group, the Science and Policy Group from New York City. They filed a brief there too. I think there might find some answers therein. So we're going to get to the hypo, just finally setting up. So In re Jennings, Professor Sarnoff has mentioned, one must start with something. The court said that back in 1959. They are very worried about this idea of just picking and choosing through the prior art because you can assemble anything. I'll say it again. Every line, every shape, every surface is in the prior art. So if you can just pick your way through like playing Mr. Potato Head, you can arrive at any design.
Now, keep a very careful look at this language. Start with something existing and the concern about selecting individual features when we come to the KSR language later. Go ahead.
So that's in 1950, 1982, after Judge Ritz had said, this is the impossible issue. The court the next year comes up with this idea of having a primary reference, a reference that is basically the same in appearance. So this was the prior art. And as tempting as it might be to just say, well, I've got the flat surface. I can take the one in the upper left-hand corner. I can flip it around, add the mirror image. Then I can take the legs, and instead of having that intersect on the side with notches, I can have the table go through that and make all the modifications are there. Every piece to the puzzle is there. But they resisted and said, no, we need a something in existence. So they took the Jennings language, and now they added this qualitative. Okay, but how close? It's something in existence. Well, one little bit is something in existence if you took it there. So they wanted to add to say, what do we really mean by here? And they said, we want more of a complete construct, something that is guarding against this picking and choosing. And their way to do that was something that was basically the same as the claim design. That phrase, for better or for worse, has sort of taken on a life of its own. What the heck does basically the same mean? For infringement, our test is substantially the same. That's how close you have to be for infringement.
To the eye of an ordinary observer. This is, remember, basically the same for purposes of the skilled practitioner's decision to put things together. So they're still mixing apples and oranges, but nevertheless, that's the language that's been in our law at the federal circuit level since '82. So thousands of patents have issued, tens of thousands of patents issued under the standard.
And designs have been rejected under that standard for failure to have a primary reference. Now, once you have the basic reference, now you can play ball, is basically what the court has said. And then you can make modifications with the secondary references in order to combine it. And this is sort of a tertiary issue in the case, but nonetheless an important one, is when can you make these modifications? Up until this point, the court has says those modifications should be for aesthetic reasons, for design reasons, not reasons of functional reasons of why you would combine to put wheels on something or to make something, a hood of a car, more aerodynamic, or a tread on a car more water resistant. Those are not the reasons we're talking about. Why aesthetically would you make these changes? Again, guarding against this sort of extreme hindsight in the design where everything is possible, but few things are obvious. So this is Durling making, again, when you can use your so related, your secondary reference has to be so related to the primary reference that the appearance of ornamental features in one would suggest the application of those to the other.
Right. So on this, when we get it to KSR again, remember that the problem that the court found in the utility patent context was requiring that the references themselves suggest the combination, rather than saying there can be other reasons to put things together. So again, you have a restrictive rule adopted and being applied routinely because of the Federal Circuit's decision from now 96.
Okay. Okay, so to the questions here, the first one, does KSR overrule or abrogate?
Okay, so we get to KSR. This is putting together a depressible pedal with an electronic sensor to be able to better control your gas. It's a throttle assembly. For 25 years, again, the Federal Circuit had adopted this rigid teaching suggestion and motivation test, saying that the prior art itself has to suggest the combination, not other reasons why a person of skill in the art would find it obvious to put the pieces together. Federal Circuit reversed the lower court's finding of obviousness. It goes up to the Supreme Court, and they said this is just too rigid a test, and they adopt this general concept that when a court, here they're talking about the Federal Circuit, transforms a general principle into a rigid rule that limits obvious inquiry, it errs. And they wanted to move to an expansive and flexible approach to analyzing obviousness. Next slide. We're doing.
Yeah.
Next slide. So they gave some examples of rationales for finding obviousness in the opinion, which the PTO then later picks up in its guidance, combining prior art elements according to known methods to yield predictable results. The key word here is predictable, simple substitution of one known element for another to obtain predictable results, use of a known technique. Again, nothing in here about the references have to make the suggestion, which is, again, the so related that it would suggest from Durling is very, very similar. Obvious to try putting things together from a number of predictable solutions. But the most important language, next slide, is what is the starting point for the analysis and what problems does the FOSTA have to address? So the first error of the Court of Appeals in this case was foreclose this reasoning of putting things together by holding that courts and patent examiners should look only to the problem the patentee was trying to solve. Second error was that person of ordinary skill attempting to solve the problem will be led only to those elements of the prior art designed to solve the same problem. Again, whether problems exist in aesthetics becomes the relevant question. If they do, and you're trying to solve a problem like how do you make this look sexy or speedy or sporty, then you don't necessarily have to even solve that problem in order to put things together and come up with the same thing. You might actually be trying to solve the problem of the actual applicant might have been trying to solve the problem of making something look speedy, and somebody else made it look sexy. But it would have been obvious to make it look sexy to that designer. That becomes a fact-based, difficult, complex question for which the concern, correctly as Chris states, is that you're using hindsight to make that decision. But the rule in KSR is it's an error to only look at the same problem. You can start with anything. Just as possible to begin with the objective to upgrade Asanas to work with a computer-controlled throttle, so too it was possible to take an adjustable electronic pedal like Rickson, seek an improvement that would avoid the wire chafing problem. And then you get to the core question, which again, Chris has pointed out, what about just putting together different things that exist in the prior art? Common sense teaches, however, that familiar items may have obvious uses beyond their primary purposes, and in many cases, a person of ordinary skill will be able to fit the teaching of multiple patents together like pieces of a puzzle. This is precisely the concern that drove Jennings and Rosen and Durling, and the Supreme Court is saying sometimes, right? Sometimes it's perfectly okay to say it's obvious by putting together random bits like you're putting together a piece of a puzzle to get something that you want. That's the core concern here. Both why KSR may overrule, make Durling and Rosen inconsistent, and the concern, I think, on the other side, that just makes it far too loosey-goosey, because anybody will now make a story about why the person of skill in the art would want to put these pieces together. So the question is what's the right rule?
Well, I mean, so there's a lot to unpack there. And KSR, one thing to note right off the bat is KSR doesn't mention once design patents. There's nothing about, design patents have been around for 1842. This design patent impossible issue has been around for many, many years prior to KSR. There's not a peep about, but design patents in here. All of the context in here is talking about solving a problem. They're talking about predictable results, obvious to try. This is, and when we get to, I'll give an example here. If you're going to sit down to build a lamp, okay, you're going to design a lamp. You start with the base. Then you have the midsection, you have the upper midsection, you have the hood on the lamp. When you sit down on that face to build it, you can make it circular, you can make it square, rectangular. You can take the facets, you can make them concave, you can make them convex, you can make them coplanar, you can make them chamfered, you can make them filleted. There is myriad design choices, and I'm only on the base. And then to go to the next, go to the midsection, you have infinite choices there, then to the next section. And what the court is basically saying is they're basically calling this out, that this is incredible, that someone could have pieced together all of these different things, because it's not like a utility patent where on average you have 6 to 7 claim limitations in a design patent claim, in a utility patent claim. In a design, you have literally hundreds of thousands of design choices that are being made or could be made, modifications to any particular surface.
So again, let's go back. One of the rationales, it would be obvious to try choosing from a finite number of predictable solutions. 3 basic choices: triangular, round, or square bases. 1 central column, square, whatever the square or round. Hat for the lamp, 1 straight. This isn't a lot of stuff. Without a time, money, or effort threshold, without understanding what designers do routinely put together, we'll come back to that when we get to the Whitman saddle, it's not clear that they can't put these together like the teachings of multiple patents to make a puzzle. And the puzzle creates an aesthetic design. And that's the core of the question.
It is the core of the question, and I don't think the court's saying that you can't put together references, but it's basically saying that as a general rule, we need a framework where you're starting with something that is basically the same, something that is a general same configuration. If you can't find something that is even generally the same configuration, that you can't even find a starting point, that's pretty compelling evidence that something is not obvious, that someone has been assembled and you can't even find something that's in the ballpark. And I think where I found a lot of the argument on the other side was to say basically the same as it's taking it's disenfranchising the one of ordinary skill in the art because it's saying it has to be the same. To me, that's a false argument. The court is never saying that basically the same is infringing or is anticipating. That would be ridiculous. That's saying it is the same. What the court was saying in these cases is we want, as a pragmatic reason, as a prudential rule, we want something that we can work with that is going to call BS on this assembling this Mr. Potato Head game. We want something that's in the ballpark. And that's all they're looking for in this case. And it's unfortunate that the cases have drifted and oftentimes look for almost much closer to anticipation, but that needs to be throttled back so this can bring some sense to this.
And we'll come back to the throttling back arguments of various people in a minute. The most important thing is to recognize that Chris is exactly right about that was the motivation for the rule that's been in place from the Federal Circuit since Rosen and Durling. That's the rule. But we have a Supreme Court decision saying obviousness should not be based on these kinds of rigid rules to prevent hindsight bias. So the whole question is it inconsistent with KSR? And that's what we're going to find out a month.
Well, I mean, who knows? It's been a month, but we don't know. But there are, I mean, to be clear, there are. The Supreme Court didn't say you couldn't have a framework. It didn't say that.
Right.
That's not what it said.
What they did say is the rigid framework of requiring TSM is not the only way to show it. The way to show it is to articulate whether there was an apparent reason to combine, which will then make it a highly fact-specific question in every case about what the prior art said, what motivations there were, all of those, objective factors, as well as what a person of ordinary skill in the art routinely does. And that means that it's going to be very expensive to litigate, which is great news, Chris.
Well, not great news for the USPTO, because they have been very accustomed to using this rule. This provides a method for them to not engage in this mixing and matching of literally 1,000 design choices for something and sifting through and hearing argument on that. It's not a workable rule for them, but as far as litigation, yes.
They will have to hire people who actually know something about how designers operate.
Yes, well, and I know they're working on that.
Right.
So where this shakes out on this question is KSR, there was not much discussion at the oral argument that, does it overrule or even indirectly abrogate. But much of the thing is, okay, let's just, most everybody agrees, at least at the highest level, the principles of KSR, that we need flexibility and an expansive approach, those apply to designs. And now it's finding, do we have a test that in its application is meeting those goals? And there's where the debate is. Any differences between designs and utility? In the interest of time, we'll just go through this. There's designs protect way things look as opposed to
Function versus aesthetics.
We talked about Gorham. Okay, should you eliminate the Rosen reference? That's the primary reference. And in just cutting to the chase, my personal opinion is, and from somebody who's been working on designs for near 30 years, is this is the most important thing. If anything comes out of this opinion, is that there is some type of preservation of the Rosen reference or of the primary reference requirement in a way that, and I think the way that they sidestep all of the concerns here about disenfranchising, just make it a general rule. Make it a general framework. This is, the amicus brief for IPLA, we laid it out. Make it a general rule that the courts can apply. Yes, you can say, well, Chris, what are the exceptions to that? We'll deal with those. And that's what the court did in Egyptian Goddess on claim construction. 97% of the courts post-Egyptian Goddess have not engaged in verbalizations of design patent claims. A few times they have, we discuss them. But as a general rule, because it's very helpful and important to bring some sense of order to this area of subjectivity.
So the one thing I'll say is that here, the key question is, what do you start with, right? And whether it's basically the same, a lot the same, or only a piece of the whole becomes the critical question. Even LKQ doesn't argue that you don't have to start with something, but they're saying if there's a reason to start with anything, you modify that anything, or you put different pieces together, you're still starting with something. So it's not that you have to start with something. The question is how close to the overall claim design does the starting point have to be? And that's highly disputed. Right.
Highly disputed. I mean, and what was posed during oral argument? Well, what about just a line segment? Is that enough? And there seemed to say that it was. Yeah. And I think that type of test will really turn things on its head.
Okay. So we'll get to Whitman Saddle, and remember the Asano case from KSR. You can start with either thing and different motivations for combining them with either thing in order to come up with the whole. That's the argument that LKQ is making. What it still requires is an articulated reason for combining these things. And that's going to be a fact-based determination in every case, which, given the number of patents that you see, means more work for lawyers. Again, great news.
It is.
Right.
Let's give this a lamp because it's sort of fun to talk through. And so these are just a series of lamps on there. And you can see that on the far right is a assembly of all those individual parts. And these ideas of making something sexy or sporty or cool, those are goals of a designer, but that's not a problem. And anything that can be definable in any way that we would want to bring into a court of law. And so the idea of here is when you're designing this lamp, all of those components are there. What would be, how are we going to analyze this? Are we going to allow you just to start from one little piece of this and then just say, well, you can add the glass midsection there. You can add that orb or sphere.
So
what's
if-
the reason for doing so?
If you start with this, let's assume this is in the prior art, and you know that these other elements are all in the prior art, the only question is would a person of ordinary skill, a designer, have a reason to combine them to get the one on the right? That's going to require articulation. And Chris is absolutely right. When you get up to 5 things put together, it's a harder story to tell. But the key is whether or not you're going to foreclose that story from being told at all. And this really goes back to our distrust of juries. And I would love to see us get rid of juries in all patent cases. I think it's idiotic, but that's just me. In any event, the question is what do designers do? And remember, these are skilled people who are in the business of trying to create aesthetically pleasing and differentiated things. I could tell a story about why they might want to come up with this thing that combines the 5, but that's going to be a fact-based question. And Chris is going to put me on the stand and say, you're just making it up, right? and the answer is if I'm a designer and I'm an expert designer, I'm being paid very well to give my opinion. Now, you can tell me whether I'm lying or not, but that's going to be the question.
And this was one of the biggest concerns of the solicitor, the USPTO,
Right.
the Solicitor General. They said, they asked the other side, how is this coming in and filing 312 amendments or coming in and filing expert declarations in the context of a patent prosecution in every one of these cases? That's not workable. That is not workable for this thing. And if you could provide, some reason, when would it be obvious to combine these things? The modifications that we're talking about, that selection and the sizing, we're here, this is an easy example because I plucked and you're literally using the same scale to put those in. That is design. The assembly of what you're seeing here in the front, that is the process of design. That's what the designer does. But to somehow just say, well, no, that's just, an ordinary assembly of known parts, like it's like children building blocks and they're assembling something. That's not, this is the art, this is the actually act of design. And it's really easy to just turn this into a mix and match and sort of denigrate the process of what designers are doing. But these spatial relationships are of precisely design.
But remember, the question is the perspective of the ordinary skilled designer. And the question still is, what do they do? And we don't have a time, effort, or money threshold. The one thing I want to correct, though, is that the 132 affidavits will come from the applicants because it's an ex parte prosecution. So you have to have the patent office examiners who have to understand. They won't get 132 declarations. They'll just say, this is the level of skill in the art. And then you'll come in and say, no, it's not, with a 132 declaration. Right?
No, that's a good point.
Right.
So this is just furthering on this example. So let's go to the...
I think we're at Whitman Saddle.
Whitman? Okay.
Yeah,
So
let's get to Whitman Saddle.
Was a good one.
Yeah.
Okay.
Back, right.
Go ahead.
So 1893, this is the one Supreme Court case we have. And you have a saddle that basically combined the front and the back of saddles in the art. No one argued that this looked basically the same as either of the prior art saddles. And what the Supreme Court says, nothing more was done in this instance than to put the 2 halves of these saddles together in the exercise of ordinary skill of workmen in the trade and in the way and manner ordinarily done. If you had to start with something basically the same, you couldn't ask about obviousness. This, of course, long preceded any of those cases that decided this. In fact, we didn't even have obviousness in the statute at that time. So the question is really using the language of the time, is this an invention being inventive in the sense of being sufficiently creative, or is this just what ordinary workmen, ordinary designers do? Because this wasn't done for functionality, it was done for looks, right? So we have one precedent saying, yeah, put 2 pieces together that neither one of them looks like the end result. And that's what people ordinarily do in this field. Fact-specific question about the design.
Sorry,
Yep.
we only have room until 1:15.
Okay, so we will wrap up very soon and ask questions. Right.
So Smith v. Wittenstown is the only Supreme Court case that is, it was really an infringement case, but they were talking about, they did mention this part about combining the two things. Was there a primary reference in the case? Rosen wasn't around until 1980. This is 1893, so it's really hard to say one way or the other. Even though you had the front half, you had the back half, but presumably the front half at some point was combined with something else, and the back half was combined with something else. So, there probably was a starting point, a Rosen reference in that. I think this is going to be really important to watch what the court does with this, because this is not going to be the last chapter. And if when it goes up to the Supreme Court, they're going to want to know, how did you navigate Whitman-Southern?
Exactly. There are other cases that came up a lot. Again, we've talked about Egyptian goddess. How related is the relevant question? I think we've talked about that. What it's important to understand is the Solicitor General basically took the position that you wanted to look at the claim as a whole, you want to look at the prior art, and that Rosen and Durling should probably be modified to be more flexible, but they didn't actually ask for Rosen to be removed. They asked for Rosen to be made more flexible. I think they did kind of ask for Durling to be removed. Okay, again, we'll skip this hypo and go to if the court were to eliminate or modify, what should the test for evaluating patent obviousness be? It seems to be that the court is going to focus on, and this was the first question out of the gate, a new analogous art standard. They'll probably follow Graham versus John Deere, and let's get to the analogous. Okay, we passed it somewhere.
It was up
Yeah.
front. You can just say what it is.
Okay, so the analogous arts test in utility law is that courts will look to say that the person skilled in the art will look to prior art if it's in the same field of endeavor or if it's addressing the same problem that the inventor looked at. Now remember, that's a decision based on a case called In Re Clay, also from the Federal Circuit. In KSR, the court said one of the problems of the rigid approach of the Federal Circuit in that case was they were looking only to the problem that the inventor applicant was trying to solve before deciding that there might have been a reason to put these things together and come up with it. You could look at a different problem. So that's the context in which the court's going to have to try to articulate how broadly to make Rosen apply and how to frame it in terms of an analogous arts test that either is different from or the same as the KSR, either the KSR or In Re Clay or something different. So with that, why don't we just ask one basic question, which is what's different about design that mandates that we can't use the Graham factors and the KSR approach? Because that's really the core of this issue.
Yeah, I think that it's the very nature of design that you are dealing with not claim elements in a functional way where there are multiple modes that could execute that particular claimed invention. But in design, it is a single invention that you're looking at. There's not multiple inventions here that is comprised of many design elements that are comprising into the complete whole. So the idea of when you have something that is that can be dissected into bits, which are all possible but none obvious, they want some construct in order to prevent that perhaps from cobbling together all these things from the prior art. So having a reasonable starting point, that's all the court really is trying to do with this. And so long as they can adhere to that principle, that we just need a reasonable, suitable starting point, something that has the same general configuration, that then you have a starting point to do that. But to allow it with the mixing and matching is going to be an unworkable rule, not good for the public, not good for public notice, not good for the USPTO, and also puts the 400,000 extant design patents all in jeopardy. So it's not a good path forward. They can easily do this by just saying it's a general rule. And you can keep status quo. They insulate themselves from Supreme Court review on this particular point, and we can go on our merry way.
I'll take the final word, and then we'll ask questions. And that is to say that aesthetics are viewed as a whole, but every aesthetic thing is made up of parts, and the parts might run into each other. And it is not actually different. What's different is you're trying to create aesthetic results rather than functional results, but they're still putting things together to come up with an aesthetic. And that is something which you have to start somewhere, but it doesn't have to be the place that the inventor did. And it could be anything, but you have to explain why. And I wholly agree that that means that if that's right, then lots of patents have issued, which now may get invalidated, but should never have issued. So with that, we'll be happy to take your questions. Van.
Chris, you said you had experience in design patents and prosecution over 30 years. I think I beat you by about 5 years. And never in that period, all of the design patent applications I filed, have I ever found, have I ever received an obviousness rejection on a design patent application? Have you?
Yeah, I've received several of them. You must have a very inventive clients. But yeah, we have received those. And I was saying increasingly, maybe it depends on the art area. I do a lot of work in smartphones. That's a very crowded art area. You do it in GUIs, graphical user interfaces. That's another very crowded art area. So you'll run into this for sure.
The other thing, remember, is that under the Durling and Rosen test, you don't have to train examiners to look to figure out what designers actually do in the field. They just have to say, is this close enough? And if they don't, if it's not close enough, you're done.
Okay. Well, let me hit on that point, because I think there was an effort in a lot of the briefing from the LKQ side to make this sound like this was very robotic. We're just looking, is this or that? But that inquiry as to whether or not you have a basically the same reference is from the perspective of one of ordinary skill in the art, looking at the claim design. Is it a minimalist design? Is it a complex design? Looking at the prior art in its entirety and seeing how close, how much of these modifications. A crease on the bottom of a leather bag for a tote bag is not the same as a crease on the side of an automobile, where you have the A line or the center line on it. I mean, that's night and day between those. So all creases are not created equal. It depends on the context. And that analysis of whether something is basically the same is a loaded factual inquiry taken from one of ordinary skill in the art. So it's not this just, does it look yes or no? That's not the inquiry. It is taken from a posita perspective.
It is taken from the posita perspective, but remember that you stop the inquiry once you say, this isn't close enough. So the whole question of, would someone nevertheless have had a reason to put these things together never gets asked. That's why you see so few obviousness rejections. Question in the back.
This one needs to be last question.
Yep. Last question. Yep.
I'm not a design patent attorney, and I'm kind of caught up on the graphics space still.
Yep.
And like Japan can make analogs as far as the closest prior art, as well as maybe in Europe you can think about closest prior art, how that's being litigated, as well as to reasonable alternatives and how they apply that to make combinations. Personally, I think analogous art in the U.S. is way too broad in comparison to globally. I'm trying to see how that. Maybe what I'm getting to is there wasn't too much thought, or another thing that came to mind was how inherency plays an issue with obviousness that has sort of tackled closely. And whether that's ever come up from the necessary flow, and then in combination with how the posita plays a role, and whether that should play a role in anticipation versus obviousness with an inherency doctrine.
So inherency is very rare because if you can't see it, it may be inherently there, but you can't see it, and therefore it's not going to be relevant as prior art.
Yeah, but there have been some cases where, this again, where I'm advocating this general rule. Just give me an example. So there was the primary reference that was asserted in that Campbell soup case, and it was a can dispenser, and they had the thing. The claim design actually showed a can in it. And the argument was, well, that can't be a primary reference because it's missing the can. And they used effectively inherency to say, well, it's a can dispenser, so we're going to impute that can would have been there in that particular position, and therefore that's not a visual difference that should count. So I think, with some just people lower the temperature, common sense, and that should prevail and still be used, I think we can be okay.
So I'll just end with, I think your question is exactly right, that we shouldn't have design and patent law in the first place, because it is an impossible inquiry, but not because we can't understand function in the same way as aesthetics, but because we never have used aesthetics for patent law, and we still shouldn't. With that, Chris, thanks so much.
Thank you for presenting. Thank you.
Great.